All rise. Please be seated.
My lords, my ladies, I'm here today on behalf. Can I start again?
Cut.
My lords and my ladies, I'm here accompanied by my learned friends Sam Wilkinson, Kez Siddiqui and Sean Giles, and my name's Arisa Azam. My learned friend and I are here on behalf of our client Terry Sims, Mr. Terry Sims. Would you like a summary of the facts of the case? Okay, my client Terry Sims is an actor of limited fame. He had an idea for a television serial recently. The storyline involved a group of young clothes designers struggling to hit the big time in a tough world of fashion. Our client spoke to a woman called Janet Nye, a well-known scriptwriter, very recently, in hope that she would create a script for it and pass on the message to a producer. Now, when she went to speak to a producer, Frank Blyton, she returned to tell my client that the television series would not have enough of a mass appeal and therefore would have been successful. Now, a well-known television company called Channel Extra, as you may know, began to broadcast a daily soap very recently called A-Lines, in which the storyline was almost identical to that of my client. In addition to this, Frank Blyton, was named and credited as the producer. At first instance, the court found that Channel Extra were approached with the idea without the knowledge that it was actually, in fact, my client's idea, and therefore they couldn't credit him. However, we are here to submit an appeal on two grounds, one of which my learned friend here, Sean Giles, will address, and the other, which I will address now, that Channel Extra were bound by the laws of confidence, and that although they were approached with the idea without the knowledge, they ought to have known that it was submitted in confidence and therefore should not have published the programme. Despite the unique jurisdictional basis of the laws of confidence, where third parties are involved and where other parties are involved, it's clear that we can come up and follow the elements that have already been stated in law. If I can refer you to, there's a third page, I'm sorry I don't have more than one copy. We will be mainly following the case of Coco and Anne Clark, in which Mr. Justice Meggery stated three elements that we will now be applying. Firstly, the information must have had the necessary quality of confidence. In a different case called Thomas Marshall and Queenly, it was stated that literary and artistic forms of information can hold an obligatory confidence. Therefore, the court may find that there is actually no problem with the fact that our client's idea was in fact for a TV show and therefore is classed as artistic and literary. Now, it's necessary for the owner, our client, to believe that the information would be injurious to him or create an advantage to his rivals, namely Channel Extra. It's clear that our client spoke tonight on the basis that he believed he was in the hope that she would come back to him with a script and speak to the producer. Now that to me shows that it's not necessary that he wanted the information to be out, but instead he wanted assistance to produce the idea and develop it fully before it would be published to the public domain. Therefore, the fact that Channel Extra created the same show shows that they had an advantage against him, as he was not credited on the actual show itself and therefore received no royalties, no account of profits for any of the show. It's also believed that the owner must believe in that the information is confidential itself. Now, you might say that's subjective, but had the idea of the show not been confidential, then I think it's fair to say that Mr. Sims wouldn't actually be, coming to court for an argument against a breach of confidence. Wouldn't be appealing in the first place. there isn't actually, it's not stated in the problem that, you know, where the conversation took place and whether that was specifically confidential. But the parties involved ought to have known that it was in fact in confidence.
Is it usually in the trade or in the industry that if somebody approaches somebody else with an idea that it's considered to be confidential?
I would say the trade.
You would say that it was usual practice.
Yeah, I mean, it's commonplace for people who come up with ideas, usually for shows or any sorts of artistic creativity. It's commonplace for them to keep it confidential until it can be fully published or until copyright laws and copyright can be claimed and things like that. We think it's commonplace for people to have an idea and only share it to producers in order to help them develop it instead of giving it out to the public domain. If I can refer you to page 2, the former two necessities that I've just mentioned must also be reasonable. In the case of A and B, Lord Wolfe stated at paragraph B that I've highlighted, a duty of confidence will arise whenever the party subject to the duty is in a situation where he either knows or ought to have known that the person can reasonably expect his privacy to be protected. Now, even though Channel X claim not to have known about the confidentiality, they ought to have known that through common practice, as mentioned above, writers or creators of ideas and information tend to keep them private and confidential until they are ready to give it out to the public domain. The information must be considered also in terms of the trade practice. Information must not be in the public domain, but confidentiality can arise when materials such as here have developed and have been created through the human mind. So the fact that it's taken our client, you know, the time and effort to creatively come up with the idea makes it unique enough. It makes it detailed enough for it to hold confidentiality, or the fact that Channel Extra should have known it would hold confidentiality because it's his idea, it's his own creation. Now I'll address the second element, which is that information must be imparted in circumstances imposing obligations of confidence. So cases have shown that obligation of confidence is not restricted to contractual relationships. So it doesn't make a difference here that Channel Extra were a third party, because third parties can still be bound. I mean, even the case of Stevens and Avery held and confirmed that secrets can be exchanged through friends and confidentiality relationships can be held there. Sorry, page 3. We'll go back to Coco and Clark. Mr. Justice Meggery then says that one must ask whether any reasonable man standing in the shoes of a recipient of information would have realised upon reasonable grounds the information was given to him in confidence. Had Channel Extra fully questioned the other parties involved, such as Nye and Blyton, they would have realised that the idea did not actually come from them originally. They may have helped produce the idea, but hopefully they would have mentioned that the idea was actually from our client. It's fair to say that a reasonable bystander would expect the information to be held confidentially had they thought that it's common practice for a person to hold the idea in a confidential circumstance. And the fact that the programme could only be developed and produced with the help from the producer, the scriptwriter and Channel Extra. Therefore, they ought to have known that they were bound within that situation by the laws of confidence.
Can I ask you a question here? Are you saying that under Coco and Clark, Channel Extra should have thought like the reasonable man and perhaps asked them where they got the idea from?
Not
Is that what you're
quite,
saying the reasonable man would do?
No, I'm just saying as in the objective test, in application of it, if they ought to have known that there was confidentiality because a reasonable bystander would have known that. Channel Extra should have known that.
That's a bit, possibly a bit far to state that a reasonable person would have known those confidentiality reasons. I mean, I would have thought that Channel Extra would have known those confidentiality from the person that brought them there.
But surely if they knew a person was bringing them the idea and that the idea was not that person's, then
I think that's where the hinge is. That if they didn't know that the idea didn't actually belong to the person that was bringing it, but you're saying that they should have known.
they should have known that there would be a circumstance of confidence.
But that's depending on the issue of confidence. You're saying that there should be an issue of confidence, but is it not depending on if they believe the idea is being brought by that person is that person's, or if it's
That's
someone
fair to
else's? So
say.
if they don't know, then clearly that they assume there's confidence there, but it might not belong to that person. But you're stating that Channel Extra should have confidence regardless of who the idea belongs to, even if they don't know it belongs to someone else.
Not completely regardless, but I suppose we can, if I'm allowed to move on, then we can return back to this issue. The only way a third party would be able to escape an obligation of confidence is if they had, for example, Channel Extra had paid for the value of the information from Mr. Sims. Now, they didn't actually gain the information or the idea in a way that they purchased it. Therefore, I don't think it's fair to say that they could escape an obligation of confidence in this situation.
2 minutes.
Also, information must have been used without the owner's authority. Now, in these sorts of situations, information will need to be disclosed to a third party in order to develop it, whether that be verbal or written. But so therefore, there are circumstances that permit some disclosure, but this does not mean that the disclosure meant it was in the public domain, because it could have only just been introduced to a handful of people in order to develop it. I'm sure you're familiar with the Springboard Doctrine, which states that general disclosure may remove the obligation of confidence, but persons under an obligation may still be held under it. And there was a case of Terrapin and Builders Supply Company, in which Mr. Justice Roxburgh granted an injunction because the defendant should not be put in a position where to make the information gained in order to compete against the person who's given them the information, and we feel that Channel Extra has gained the information but used it in an advantageous way against our client. So, in summary, Channel Extra uses Springboard Doctrine for their own show, and therefore it's a detrimental act to our client. Now, there was a case of Fraser and Thames Television in which the facts are pretty much exactly the same as here. Would you like to know the facts of the case?
No, I think we all know the facts.
Okay.
It's been 30 minutes.
That's okay, continue.
I just literally need 30
Yes,
seconds.
because you did have to do the bit at the front, and we have stopped you a few times, so we'll give you a couple more.
Okay. Now, the fact that there was an oral communication here, a TV show was created, we feel that because the facts are pretty much exactly the same as here, and in this case, the court rejected the argument that the idea needed to be in a form of synopsis written down or material form. We feel that that's unacceptable. It's not necessary for that to be done. In this case, an injunction was granted and there was an oral communication, but it was granted because there was a breach of confidence. So, Mr. Justice Hurst has said here, sometimes disclosure is needed for development of an idea, and we feel that because that case has the same principles, that we feel it should be applied similarly here, and that our client would not necessarily want an injunction, but would like to be credited for his ideas, and Mr. Sims would also like an account of profits that have been made from the TV show. I'll refer you now to my friend for a second submission.
Thank you. My name's Sam Wilkinson. My learned friend on the other side has introduced me. Thank you very much for that. If I could refer you first of all to my skeleton argument, I'll be dealing with these first and second submissions for the respondents' channel extra. So our first submission is that the respondent, channel extra, was not bound by the law of confidence because it was an innocent third party and it came by the confidential information without actual or constructive notice of the fact that the information was to be treated confidentially. And we'd like to rely on the case of Fraser and Thames Television for this case. I'd like to point out first of all a couple of notes that I've made regarding my learned friend on the other side's submissions. Opposing counsel has made its submissions on the basis that Channel Extra knew that the idea belonged to Mr. Sims, which, if we refer to the facts of the case, the court of first instance actually did find that Channel Extra were approached with the idea without knowledge that the idea belonged to Sims, and that no direct breach of confidence had been made between Channel Extra and Sims. My learned friend has also referred to the case of Fraser and Thames, which we are going to rely on. In this case, as my learned friend has already said, the facts were very similar. It was regarding a It was an idea for a TV rock series, and the claimant communicated her ideas to the defendant, who was a scriptwriter, who then communicated the ideas then onto a producer, and a similar situation arose. However, we'd like to distinguish the current case from this case, actually, because in that case, the third party in question actually knew that the information was to be treated confidentially, whereas in this case, Channel Extra, my client was not aware that the information was to be treated confidentially, so we believe that that cannot be applied directly to this case. I'd also like to cite the case of Prince Albert and Strange. In this case, the claimant made and owned etchings for his own personal use, and a workman of the claimant dishonestly came by the etchings and took impressions of them, and they were then sold on to a third party who published a catalogue of those etchings. The court granted an injunction against the defendant in that case, and held that a remedy can be granted against a third party to a breach of confidence if they knew that the information was confidential. And again, we'd like to distinguish the fact that the court has said that this is the situation where a third party can have an injunction brought against them for a breach of confidence, but only when the third party was aware actually that the information was meant to be treated in a confidential manner. My second submission, if I may move on unless you have any questions. My second submission is in regards to remedies, because as I'm sure your lordships are aware, there are generally two remedies in relation to breach of confidence. Obviously there's the common law remedy of damages and the equitable remedy of an injunction. In relation to damages or an account for profit, which my learned friend on the other side has proposed, it is submitted that for a grant of damages to be appropriate, there has to be a direct breach of confidence between the claimant and the defendant, and in this case it is submitted that there is no direct breach of confidence, as it's already been established that Channel Extra were not aware that the information was to be treated in a confidential manner. In relation to an injunction, which although an injunction can be granted in a situation where there is no direct breach of confidence between the claimant and the defendant, as we've seen in the case of Prince Albert and Strange, and also a couple of other cases, Sharing Chemicals and Falkman was another case. But we would like to submit that an injunction would not be a suitable remedy in this situation. And I'd like to refer your lordships to the case of Attorney General and the Observer Limited and others, which is in my skeleton argument. Would you like a brief summary of the facts of this case?
No, we know the facts of this case.
Okay. So,
5 minutes.
pardon?
5 minutes.
In that case, the court held, Lord Justice Griffiths held that a third party who knowingly receives the confidential information directly from the confidant is tainted and will be restrained from using it. If, however, before the confidant can act, his confidential information has spread far and wide, and a third party is not tainted or associated with the original breach of confidence, and he will not be restrained from using the confidential information that is now public knowledge, even though he may realise that the information must have been leaked in a breach of confidence. It is submitted that this is appropriate. This case can be directly applied to the present case because the information has now been used to make the television show A-Line, and that information is now in the public domain. Also, we would like to draw a correlation between the defendants in this case, which in this case was newspaper companies, and Channel Extra in the present case, in that they were a third party to a breach of confidence that was committed by that was committed between the original confidant and someone else, and that therefore they did not owe a duty to the original confidant because they weren't party to the breach in the first place. Yeah, I think that concludes my submissions. Do you have any questions?
My name is Sean Giles and I stand before the court as junior counsel for the appellant Mr. Sims. Before I move on to my submission that there was no public interest defence available to Channel Extra, I'd like to rebut a few points put to me by my learned friend. Mr. Samuel, firstly, we would argue that the case of Fraser and Thames TV is directly analogous to this case, because in that case, to remind you of the facts, a few actresses got together with an idea, took their idea to a script editor. The script editor then took that idea to several TV companies, and one of those TV companies failed to acknowledge the right of refusal that was contained in the oral agreement that was made. We would argue that this is exactly the same as Mr. Sims going to Mr. Nye, telling him his idea to produce a TV show, taking that to different companies, and then one of those companies stealing that idea. It's submitted that it's common practice that ideas for TV shows, artistic works, literary works, is subject to a breach of confidence because your idea can allow you to make money. So it's common knowledge that if I were to tell you a really good idea, I would expect you to keep that idea secret, unless I told you otherwise. In this case, we'd say that the idea was authorised to go via a script editor to TV companies. It was not authorised to go and become a TV show without reference to or damages or royalties paid to Mr. Sims. I'll scroll and move down to my submission that there is no public interest defence available. My submission splits into two parts, which is firstly that the defence of breach of confidence, that it's in the public interest to disclose that confidential information, is inapplicable here under all common law, equitable rules, or the definitions contained within the European Convention of Human Rights, which I'll just call ECHR for convenience. My second submission is that there is actually, in fact, a public interest defence on policy grounds of protecting our client's idea. So move on to my first one, which I'll start by explaining the importance of this point, which was espoused by Lord Denning in Fraser and Evans, in which he said, "No person is permitted to divulge to the world information which he has received in confidence, unless he has just cause or excuse for doing so, even if he comes by it innocently. Nevertheless, once he gets to know that it was originally given in confidence, he can be restrained from breaking that confidence." In this case, this is important because although Channel Extra did not know at the time now they are aware it's confidential. So it's irrelevant whether they ought to have known or did know. The fact is now they do know, and our client should be compensated as such.
Are you asking, so you want compensation instead of
Well,
what was stated by
damages,
Lord
let's
Denning
say.
that to stop them?
Well, an injunction, I agree, is entirely inappropriate because the information has already been leaked to the public.
5 minutes.
The breach has occurred.
So I'll move on to what public interest means.
It's a notoriously nebulous subject. I think maybe the clearer way of defining it is espoused in ECHR Article 8.2, which provides for when you're allowed to breach someone's right to privacy, which says that it must be necessary in a democratic society and in the interests of national security, public safety or economic well-being, prevention of disorder or crime, or protection of the rights and freedoms of others. I think it's fairly obvious that none of these actually apply to Channel Extra, and so I won't discuss them any further.
So is it not a right to respect private and family life, not a right to private and family life?
I think that's an arbitrary difference in this case. I don't think we're discussing private correspondence in it, we're discussing private ideas. I'll then move down to what the Press Complaints Commission, now defunct, describes in its Editor's Code of Practice from the 1st of January 2012 as when you're allowed to use a public interest offence to leak confidential information. These are defined as detecting or exposing crime or serious impropriety, protecting public health and safety, preventing the public from being misled by an action or statement of an individual or organisation. Again, I feel none of these are relevant. Disclosing our client's idea to the public is not going to protect the public in any way or expose any crime or serious impropriety. I think that's fairly clear.
And if we also look at cases where public interest has been applied,
You'll see the spy capture cases and the case of Mine Laboratories. Both of these actually dealt with quite serious public interest issues. The first case was about disclosing information withheld under the Official Secrets Act. The latter dealing with breathalyzers for the police that were in fact not tested properly. Clearly this information not being released would pose a danger to the public.
none of these, I think, apply to the current case. And in fact, I would argue that the only relevant category from Article 8.2 of the European Convention of Human Rights is that economic well-being may be allowing people to exploit their ideas to make money. Now, arguably I'd say that more applies to our client than to Channel Extra, and that's our client's right to exploit its ideas, sell its ideas, and develop its ideas, maybe with the assistance of others. I'll now move on to my second ground, which is that, as a matter of public policy,
our client's ideas should be protected by the law of breach of confidence. Firstly, I would argue that not imposing such an obligation will lead to people not using the law of confidence or intellectual property law to protect their innovation. This is because clearly there's nothing afforded to embryonic ideas that haven't been fully developed yet. So the way that they'll have to get around this is by just keeping trade secrets and not exposing it, which means this information will never become into the public domain and will never be able to inspire innovation for future generations. Instead, breach of confidence protects these embryonic ideas and enables them to be developed to a point where they fully come to fruition and copyright law can become relevant. If breach of confidence is not imposed early on in the conception of the idea, then the idea can never develop at this point.
then I have a quote
From Lord Justice Simon Brown in the case of Crown against Department of Health ex parte Source Informatics Limited, in which he said, this is the second of the four main classes of information which traditionally have been protected, or whose use has been restricted by the enforcement of confidences. He then lists these confidences: trade secrets, personal confidences, government information, and artistic and literary confidences. I think quite clearly here, an idea for a TV show is, let's probably say artistic rather than literary, a confidence that should be protected under the law of breach of confidence. This is again reinforced by the fact that there is a convention for the protection of literary and artistic works dating back as far as 1886. I think it's a fairly established principle that even embryonic ideas should be treated confidentially unless or until they are fully developed. That concludes my submissions.
My lady, as already stated, my name is Kester Vicky, and I appear as junior counsel for the respondent. My lady, I have one submission to make. If it pleases your ladyship, I will begin my first submission.
There are three of us sitting here.
Ladyship and lordship. May I submit that the public interest defence is applicable and can be relied upon by Channel Extra on my client. This is due to the fact that the Channel Extra, having produced the show A-Lines, is in the public interest, as opposed to what the public is interested in. In Attorney General and Guardian newspapers, the Spycatcher case, Lord Gough at 282 stated that the third limiting principle is of far greater importance. It is that although the basis of the law's protection of confidence is that there is a public interest, that confidence should be preserved and protected by the law. The limitation may apply to all types of confidential information, So applying this to our case, it can also include TV shows, ideas of TV shows. However, Extra were not even aware that, I have to submit that Extra was not even aware that it was someone else's idea. In addition, we have to bear in mind in the words of Lord Wilberforce in British Steel Corporation, where he said that there is a wide difference between what is interesting to the public and what is in the public interest to make known. Furthermore, Lord Justice Stevenson said in Line Laboratories at page 537, the public are interested in many private matters which are no real concern of theirs and which the public have no real pressing need to know. My lady, it is for these reasons and also those given by my senior counsel that I would urge you not to allow the appeal. If your ladyship and lordship has no further questions, that concludes the case for the respondents.
Thank you, ladies and gentlemen. We will now have a short recess while we consider.
They kind of did that.
I just have one very quick point to make. My learned friend mentioned that Channel Extra did not, she made a point about there being an exception for where a third party has made a bona fide purchase for value without notice for the idea. I just like to point out that if in fact Channel Extra purchased the idea from Blighton, then they would be protected by that exception as well.